have stood at the front lines of law, leadership, and public service. Attorney Karen Jimeno, sharp, steady, a lawyer, and educator, turns complex issues into clear insight. Attorney Mike Toledo, seasoned, fearless, a strategist and communicator whose voice has shaped public understanding of law and governance. Together, they make the law accessible, connecting principles with real-life questions, confronting the issues that define our nation. This is ABOGADO.
Good evening and welcome to ABOGADO, the show where we confront the nation's most pressing legal and constitutional questions. I'm Attorney Mike Toledo, and tonight we take on an issue that cuts deep into the principles of governance, where law, ethics, and accountability collide. It's a question that challenges how we define fairness and how far institutions should go to protect public trust. Let's take a closer look.
Allegations of corruption can shake public trust even before a case reaches the court. But what should happen to lawmakers while investigations are still ongoing? Some believe they should continue performing their duties, presumed innocent until proven guilty. Others argue that allowing them to stay in power during active investigations may compromise evidence, influence witnesses, erode public confidence in the system. Would temporary suspension protect the integrity of the investigation or unfairly punish someone not yet convicted? It's a question of accountability versus due process. Should lawmakers be temporarily suspended while facing corruption investigations?
We are indeed fortunate because joining us tonight are three of the country's leading legal minds. Seeing merit on both sides of the issue is Dean Jord Jharoah Valenton, Dean of the University of Makati College of Law. A bar top-notcher and a Harvard-trained legal scholar, he is known for his expertise in mining, environmental, and arbitration law. Beyond the courtroom, he continues to shape young minds as a professor, author, and managing partner of Manalo Valenton Law Offices. Believing voluntary inhibition is better than suspension is an old friend of mine, Dean Soledad Mawis, Dean of the Lyceum of the Philippines University College of Law and Chairperson of the Philippine Association of Law Schools, a revered educator, bar reviewer, and an author. Dean Sol has also served on the Supreme Court's technical working groups for the revision of the rules of civil procedure. And now firmly opposing suspension during corruption probes is Attorney Adonis Gabriel, a distinguished political law professor at San Beda College of Law. He graduated valedictorian of his class and ranked among the top-notchers in the 2001 bar examinations. A respected educator and scholar, he served as 2024 bar examiner for political law and public international law. Well, welcome to the program, deans, counsel, and top legal minds.
Good evening.
I'm sure this is going to be definitely going to be a very interesting discussion. Now, before we begin, let's take a look at how tonight's discussion will unfold.
We begin with the opening statements. Each speaker presents their position in a focused 2-minute statement. Next, we explore 2 subtopics. For each, the guest supporting proposition speaks first, followed by the opposing guest, 2 minutes each. Then comes the open exchange, a 6-minute back and forth where both guests ask, respond, and engage freely. Afterward, closing reflections. Each guest summarizes their key points in 2 minutes. Finally, the hosts step in. In a 6-minute segment, they raise final questions and guide deeper discussion.
And now we begin with the opening statements. The question, should lawmakers be temporarily suspended while facing corruption investigations? Dean Jord, you have 2 minutes.
Thank you, Mike.
Well, coming here, my client has been calling me as regards her kasambahay, whom she caught stealing. And she was asking what she should do, and I told her we should be filing a qualified theft case and have her terminated, have her employment terminated. If we could require integrity, decency, and respect for laws from our kasambahay, with more reason that we should be requiring the same from government officers. The Constitution requires that the public office is a public trust, and officers should be accountable at all times, and they should act with responsibility, integrity, and efficiency. And part of accountability is what we have here, preventive suspension. Part of accountability is that they face the process, and the process requires preventive suspension that is provided under the Local Government Code, RA 3019, and the Ombudsman's Act. And another reason why there should be preventive suspension is to preserve the integrity of the process. Because by them being in office, they will be able to influence witnesses and tamper records. But is it constitutional? Yes, because of two things. Number one, due process. Number two, the preventive suspension is not indefinite. Thank you.
Thank you so much, Dean George. Now, Dean Sol, your opening statements.
You know, suspension in the Philippines is a very touchy issue, especially when it concerns lawmakers. To begin with, okay, one can be preventively suspended provided that there is a law allowing it. Now, is there a law that can preventively suspend, let's say, lawmakers who are involved in, let's say, anomalies? First, of course, the Ombudsman. Under Section 13 of RA 3019, provided that there is a case or evidence of guilt is strong and the offense involves graft, corruption, and dishonesty, of course, the person and the continued stay of the person will allow him to tamper evidence. For example, he can be preventively suspended. Now, second, as far as the Senate and the House are concerned, they can, if they want to, by 2/3 vote, suspend and even kick out, a lawmaker. So clearly, there should be a process by which you can preventively suspend a person. Without a law allowing preventive suspension, then we might violate due process. And that's my point when it comes to preventive suspension. There should be a law that allows that, absent which then it might be considered unconstitutional because you're depriving person's right to, to continue with his employment or job.
Thank you so much, Dean Sol. Now, on the other side, Attorney Adonis, your opening statement.
Yes, good evening, Mike. Good evening, Deans. Yeah. So definitely, members of Congress are public officers. As public officers, they are subject to the principle of accountability under the Constitution, specifically Article 11 of the Constitution. But like private individuals, members of Congress are also protected by the Constitution. Because if we exempt the members of Congress from the coverage of the Constitution, particularly those who look like guilty of charges, then we will also be depriving the same protection from those who are innocent. Suspension presupposes, or suspension can be taken in two ways. It could be as a penalty. It could be as preventive suspension as a part of the process in order to maintain the credibility of the proceedings. Definitely, suspension as a penalty cannot be imposed to members of Congress during the pendency of the investigation. So there must be a complaint filed in the House where the member of Congress belongs, and as Dean Mawis said, they have to comply with the 2/3 vote requirement under the Constitution. So imposing a penalty of suspension just because there is a pending investigation definitely violates the Constitution. As to preventive suspension, Republic Act 3019, particularly Section 13 of Republic Act 3019, allows the preventive suspension, but subject to the condition that there is a valid criminal information filed against a public officer. And this also includes members of Congress. So in Santiago versus Sandigan Bayan, the Supreme Court categorically ruled that members of the Congress, while subject to the disciplinary authority of the Congress, is also covered by the Ombudsman law, as well as the Anti-Graft and Corrupt Practices law. So, but nonetheless, there are conditions. There must be a valid criminal information filed against that member of Congress, and that the condition that it involves dishonesty, fraud, and that the likelihood that he may be found guilty is also strong.
Thank you so much. Thank you so much, Attorney Adonis. And you're talking about that case, I think it was decided in 2001, all the way back then. And now let's start with the legal foundation. As we all know, Article 6 of the Constitution vests the power of discipline in each House of Congress. And you sort of mentioned it already, Dean Sol, earlier on in opening statement, not in external bodies. And yet, anti-corruption and ethics laws push for higher standards of conduct. So the question is, would the temporary suspension of lawmakers during an ongoing corruption investigation encroach upon the constitutional due process and the autonomy of Congress itself? Now, Dean Jord, your thoughts?
Yeah, you raised two things. First is the autonomy of Congress. The second is due process. With respect to the autonomy of Congress, indeed there is separation of powers under the Constitution, but powers are not absolute. And Attorney Adon did say about Santiago, where the Supreme Court said that it's not just Congress that has exclusive power to act on complaints against public officers. And RA 3019, Section 13, as mentioned by Attorney Adon, specifically says that elected officials are subject to the law, which allows preventive suspension. Now, with respect to due process, there will still be due process because we distinguish suspension as a penalty from an interim measure. This preventive suspension is not a penalty. It's just an interim measure, and I mentioned a while ago about the purpose. And due process shall be afforded the subject elected officials because there will be pre-suspension hearings where it will be determined whether or not the evidence of guilt is strong. And number two, as under RA 3019, there should be a valid information. So those two, the preventive suspension does not encroach upon the separation of powers. The preventive suspension affords due process.
Thank you so much. Dean Sol, your view?
You know, insofar as preventive suspension is concerned, again, I subscribe to the view that there should be due process. But be that as it may, preventive suspension becomes necessary, especially for the legislature, because it protects the integrity of the legislature. Secondly, it prevents obstruction or tampering, especially if the person concerned has access to important documents. Third, it signals commitment to accountability. And finally, it minimizes conflicts of interest. But be that as it may, even if we try to achieve those goals, at the end of the day, give the person an opportunity to be heard. We cannot immediately condemn them, even if in the concept of preventive suspension. There must be due process and compliance with substantive due process at the very least.
And now, thank you so much. Attorney Adonis, your perspective on due process and the autonomy of Congress.
In the College of Law, we are taught that our government is a government of laws and not of men. So, members of Congress may look guilty about malfeasances or misfeasances in office, but we have principles protected by the Constitution. And you mentioned separation of powers. Under the Constitution, the three departments of the government are independent and each is supreme within the respective jurisdiction. One cannot encroach or interfere with the affairs of the other. Okay. So, under the Constitution, the exclusive power to discipline a member of Congress rests on the Congress. So, the imposition of preventive or suspension as a penalty, while the investigation is still ongoing, definitely violates the Constitution. Again, preventive suspension is only allowed under Republic Act 3019 whenever there is already a criminal information filed in court. So if it is just an investigation, if the investigation is still pending, meaning there is no criminal information yet, then we cannot impose preventive suspension even if there is a strong evidence that the members of Congress may have committed something wrong. Again, ours is a government of laws and not of men.
Is what you're saying also what the Supreme Court held in Trillanes versus Pimentel, when they said the congressional autonomy is superior of the power to discipline?
Okay. So, the power to discipline the members of Congress rests exclusively on the Congress itself. But of course, members of Congress are also subject to the accountability. So, the administrative power of the Congress is not mutually exclusive with the powers of the court to impose penalties in criminal cases. But in administrative cases, the power of the Congress is superior over the other departments of the government.
Okay, and now we open, as we mentioned earlier, this is how the show progresses. Now we open the floor to a 6-minute exchange. You may respond, ask questions from one another, or rebut. So who wants to begin? Would it be the lady first?
I just would like to
Dean
ask their
Sol?
opinion,
Yeah.
actually. You know, given what's happening now in Congress and
Yes.
Senate, persons are named, and yet, of course, there is no complaint yet filed, even in any commission or any body. But you know, people are really asking, what should be done? I mean, there should be a sense of accountability or delicadeza. My question now is, given the absence of a formal complaint or charge, is it not maybe the proper thing to do for them, for those people who were allegedly part of this grand conspiracy, to just recede in the background first instead of actively participating, in the discussions when their names precisely are being floated as one of those who
So you want
contributed?
them to voluntarily
Yes,
inhibit?
especially in the absence
Okay.
of a complaint that's filed.
Okay.
No?
Any comments from the gentleman?
I totally agree, Dean Mawis. Okay, so propriety is one thing, constitutionality or legality is another thing. So again, the Constitution protects the rights of the people, as well as the rights of public officers. And at the same time, the Constitution also imposes an obligation on the part of the public officers, including members of Congress. It is their right to be protected with the Constitution, but they have also the obligation to be transparent and to participate in the discussion or in the investigation and not to interfere with the investigation. So if it is inhibition, voluntary on the part of the Congress, while it is not written in the Constitution, there is nothing in the Constitution, if we read Article 6 from Section 1 to 32 of the Constitution, there is nothing there that allows members of the Congress to voluntarily inhibit. But nonetheless, in one case, Abbas versus Senate Electoral Tribunal, the Supreme Court said that while they may not be disqualified, they can, on their own volition, inhibit in order to show delicadeza, in order to show that they will not interfere with the investigation.
What can you say, Dean George?
Dean Mawis mentioned of inhibition, and that's good. It's just that we cannot leave the rule of law to the sense of propriety of people. We have laws.
So you don't trust so much certain people? Okay.
Well,
You don't look at the better side of the angels, so to
I don't
speak.
want to rely on the
Yeah.
goodness of people.
Okay.
Especially when we're talking about accountability.
I know some philosophers exactly like that. Please go ahead.
Yes, so I don't
Yeah.
want to rely on the goodness of people, since anyhow we have laws in place. We mentioned of the laws a while ago. Well, I do consider that there is a presumption of innocence. And the congressmen, all accused, all respondents are presumed innocent. Accusation is not tantamount to guilt. In case of doubt, they resolve everything in favor of an acquittal, in favor of exoneration. However, this is not violated by the preventive suspension because anyway, the charges will still be heard. This is not a penalty, as Attorney Adon was saying. The wheels of justice will still go. He will be heard. He will be allowed to compulsory processes. He will be allowed to present witnesses. And in the end, it will be about the evidence. So presumption of innocence is not violated. Constitution is not violated. Everything is harmonized by the laws, by the Constitution, and Santiago versus Sandiganbayan.
Actually, all of you raise very, very good points. But I guess it's a question that I can throw to the three of you. Because alam mo, sa totoo lang, di ba, nakikita naman natin, no, lahat ng mga government officials na kinakasuhan, whether it be members of Congress or an executive, in the executive department, for example. Pero di ba, ang perception kasi talaga, and rightly or wrongly, we all know what the purpose of preventive suspension is. And as these are the things that you mentioned already, to initially make sure that hindi niya magagamit ang pwesto niya para ibahin yung ebidensya or manggulo siya. No? Pero yun nga masaklap. Kasi pag ikaw ay nakasuhan, whatever case that may be, administrative or criminal, and you're preventively suspended, and you come out in media, ang perception ng taong bayan ay guilty to kasi sinuspend eh. Di ba? Hindi talaga na-explain sa taong bayan, preventive suspension lang ito. Hindi ibig sabihin na may kasalanan siya. Ito talaga ang procedure, pero magkakaroon pa rin ng kaso. Kung criminal case, proof beyond reasonable doubt. Kung administrative or civil case, the preponderance of evidence. So, ang punto ko dyan, di ba, paano natin niya i-handle? Na, may marami na akong kilala na preventively suspended. Some of them are my friends, some of them were my clients before when I was actively practicing law during my younger days. And the fact that you're already preventively suspended, it is the headline news. Wala na eh. Sira ka na eh. And then assuming na lift your suspension and you're found innocent pa, it will not even make the news. So how do you deal with that? If I may just pick your brains on that. Who wants to start?
Well, for me, I would have to quote the new department order of the Department of Justice, which requires this at this time not just probable cause, but reasonable certainty of conviction. So in other words, it would not be easy for one to just file cases because we have the right of the accused against malicious and ridiculous and baseless persecution. So we have things in place.
We recently had an episode on that. Yeah, and I guess at the end of the day, we said it really depends. Are you with the private prosecutor, or with the respondent, or the defense? I think we ran out of time for that particular topic, so now we move on to the next. But that was definitely a very interesting discussion. Let's now turn to ethics and perception. In an era of social media and instant judgment, which I already touched earlier on, allegations like this can really destroy reputations. But can public trust be preserved if lawmakers under investigation continue to wield power? So, Dean George, your thoughts first.
Ethics, you mentioned the social media. Everyone is given the opportunity. The prosecution is given the opportunity to present evidence. As I said, evidence of it's the burden of proof is on the prosecution. The accused does not even have to present evidence. You can file a demurrer to evidence because the presumption of innocence is provided in the Constitution. It's the Constitution itself that provides your defense. So, while much is to be improved about the process, the fact that there is an opportunity for the state to present evidence and for the accused to present evidence levels the playing field.
And now, how about you, Dean Sol? What do you say?
I will not answer based on law. I will answer based on perception. There are some lawmakers, with all due respect, they do not treat people with even a tinge of presumed innocence. And you know, when the camera now is on their side, they will always claim now, I am presumed innocent. So maybe in an ideal world, this presumption of innocence should be respected first by the lawmakers who are asking the questions, so that if at one point in time they are being asked, then they can be presumed innocent too. Parang pa sa bumabalik kasi minsan eh. Minsan kasi, pag naririnig mo, if somebody claims, I refuse, I do not want to answer because it might incriminate, immediately, ang presumption, he is not innocent. So yun ang masakit, no? Because that is what we see on TV too.
Tama ka. And talagang, di ba, common sense kasi, if you take away the legal procedure, the rules of evidence, the rule of trial, common sense is, if tinanong ka at hindi mo sinagot, may tinatago ka. Yun lang naman eh. Yun lang talaga. But very, thank you so much, Dean Sol. Now, Attorney Adonis, your thoughts on ethics and accountability.
Public perception is indeed very powerful. Okay, so a statement often attributed to Voltaire says that I may not agree with what you say, but I will defend to death your right to say it. That is the essence of a democratic system of government. So you can shout at the top of your lungs, provided that you respect the other people to shout at the top of their lungs as well. So insofar as public officers are concerned, the Supreme Court repeatedly said that public officers must not be too thin-skinned. So the Supreme Court said that they may be injured, they may be humiliated, but their hurt can be assuaged with a balm of a clear conscience.
U.S. versus Bustos.
Yes, U.S. versus Bustos. So in the it's an old case, but the statements of the Supreme Court are still very relevant today.
True.
Okay, so we have to culture a community who can speak their mind, but at the same time they have also to respect the opinions of the others.
Thank you so much, Attorney Adonis. And now, again, we open the floor for a 6-minute exchange since the lady went first. Who among the gentlemen would start the ball rolling?
Okay, so ethics. Again, the question on accountability. Again, I have to go back to the suspension. So we have Republic Act 3019, and there are conditions for the imposition of Republic Act 3019. But we are saying we have to brush aside the law. We have to preventively suspend the members of Congress because it's ethical. But the question is, who will impose the preventive suspension? Can it be the courts? Can it be the office of the president? Or can it be the Congress? So my position is the preventive suspension under Republic Act 3019 is the only basis of preventive suspension that can be imposed by members of Congress. Unless and until there is another law, unless and until we repeal the law, then we cannot use ethics in order to impose this preventive suspension to members of Congress.
Any rebuttal, response, question?
Well, I have to say that with great power is a great responsibility.
Oh, Spider-Man.
Yes, these public officers wield so much power,
Yes.
wield so much influence. And with that power is a great responsibility to the nation. And those standards, in the end, I hope, well, this is a hope, these standards, these high standards would leave us with just the patriotic, the nationalistic, the competent to lead the country.
You know,
Yun
after
so?
listening to Professor, you know, I think at the end of the day, all these investigations in Congress should lead only to one resolution, for them to pass a law for themselves, precisely to establish ethical, you know, to make into a law what should be the ethical considerations the lawmakers must comply before they can be called lawmakers. Because at the end of the day, you are very right. How can you suspend somebody in Congress when Congress itself does not have any law or mechanism, except, of course, the Constitution in 2/3 vote? But while the case is, well, the investigation is pending, is there any law that would require, that can be the basis for their preventive suspension? Right now, there is
There's
none.
none.
Yeah.
So, okay, it's a good point that you raise, of course. But the possibility of such a law to be passed, would you say, is it similar to the possibility of a dynasty bill being passed?
I agree.
So,
I also agree, Mike.
so you know, that's the thing. It's good. Legally, it's good. But really, the possibility of passing such, like for example, we touched it in another episode, but the possibility actually of making all public officials, for example, we have the most restrictive bank secrecy laws, di ba? So kung sana na lang, parang automatic na pag public official ka, may si-assign ka na sana waiver, automatic. No? Aside from the SALN, no?
Yes.
But as to that becoming a law, it's another matter that it will be close to maybe impossible. But at least the hope is still there.
But
Yes.
there's a remedy, Mike.
What is the remedy?
We have the initiative on law. Under Republic Act 6735, the people can exercise the right of initiative to propose a law, subject to
yes.
the ratification of the people, of course.
Yes,
So it's about time that the people have to wield their powers under the Constitution. So the people might have forgotten that there is a mechanism under the Constitution that allows the people to act proactively if the members of Congress do not perform their constitutional duties. So same with
Yes.
the anti-dynasty law.
Yes.
So it can be proposed through initiative.
I think that's a very good point that you raised, and especially nowadays that the people are really looking at what's going on, and the people have really gone. I mean, let's face it, the rallies have shown that they have really been up to here as far as the abuses that were done recently because of the anomalies involved with the budget and the flood control projects. And maybe this is the time. I guess we just have to educate our people, and hopefully this is one of the shows that can do that. Na sa ating saligang batas, meron din silang power to initiate certain things, just like similar to to initiate the amendments to the Constitution.
Yes.
So siguro that is something that perhaps all the legal experts out there should study deeply and perhaps educate your own constituents. And if you are not happy about how things are going on in Congress as far as lawmaking is concerned, especially for certain specific laws, baka kailangan na pong tignan itong batas na ito. Magandang punto na raise mo yan. No? So anyway, we'll just pause for a quick break. And when we return, our guests will deliver their final reflections. Don't go away. This is Abogado. Stay with us. Welcome back, and you're still watching Abogado. Tonight's debate centered on whether lawmakers should be temporarily suspended while facing corruption investigations. We have with us Dean Jord Jharoah Valenton of the University of Makati School of Law, Dean Soledad Mawis of the Lyceum of the Philippines University College of Law, and Attorney Adonis Gabriel of the San Beda College of Law. Now, to all of you, we now turn to your closing reflections, and perhaps we can start with you, Dean George.
Yes. The last words a while ago were about initiative. I think we have to wake up. This is enough. Corruption kills and corruption steals, and the greatest victim are the poor. We talked about the balancing of interests, the interest of the accused and the interest of the public interest on accountability. I would like to tilt the issue in favor of accountability. Anyhow, these public officers went to public office knowing what they are supposed to do. They should be held on on their promise to serve. Thank you.
Thank you so much. Dean Sol, your reflections.
You know, under the labor code, a regular lowly employee can be preventively suspended, of course, subject to certain conditions. I think with all the more reason that lawmakers who hold positions of trust should likewise be preventively suspended, but of course, subject to certain conditions, and there must be a law allowing it. Because at the end of the day, everybody must be accountable. You cannot use your position to wield power or abuse power. You should be held accountable because your position is one of accountability.
Thank you so much. Very good points you raised there, Dean. And of course, finally, Attorney Adonis.
Okay. I am one with the people shouting for accountability. I also want accountability. But we have to be reminded of our constitutional, of the constitutional limitations. If we remove the constitutional limitations in order to go after the seemingly corrupt public official, we are also removing the constitutional protection for those who are innocent. So always remember that the Constitution is not only intended to protect the innocent, it is also intended to protect those who are guilty or imprudent. Because if we set aside the constitutional protections just to demand accountability, then we're also opening the floodgates of abuse to those who are innocent in the government.
Well, yes, as they say, if you, for the sake of convenience, you try to sort of work around the Constitution, it does open the floodgates, and we've seen it happen many times here in the Philippines and even in other parts of the country. And now, before we end, perhaps just a question to all our panelists, like because you raise a good point there. about using the provisions of the Constitution to perhaps let the people initiate it. So would you, I would start with you, Dean Jord, would you be supportive of such a move, and if so, why?
Of course, because power is vested, sovereignty is vested in the people. And it is the greatest manifestation of this power is for acts, for laws to be initiated by the people in whom sovereignty is vested.
Dean Sol?
I'll say a short statement. I concur. I truly believe that that is very, very right. I thank you for informing us and reminding us, because we should exercise that right.
And Attorney Adonis?
So, for several years, we have been exercising our constitutional rights and at the same time participating in extra constitutional activities. We have revolutions, we have EDSA Revolution 1, EDSA Revolution 2. When will it end? Okay, so we have a basic and fundamental law. We should not lose our sight on the rights and the privileges under the Constitution. Otherwise, we will not go anywhere if we will not exercise our constitutional prerogatives and privileges.
Well, thank you so much, Attorney Adonis. You know, during the break, we sort of had a this mini discussion of sorts, and we were both in agreement. Kami pong lahat dito ng mga abogado, kami apat na abogado, at I'm sure si Attorney Karen will also agree with us, na talagang siguro we should really look at that possibility at studying that provision of the law in the Constitution that will allow actually the people to initiate the passage of laws that are supposed to be passed because it is mandated by the Constitution itself that there should be such a law, and yet for reasons that we already know and for a plethora of reasons that are quite obvious, siyempre hindi pinasa, no? At hindi pa malamang hindi na ipapasa. Perhaps even including the idea of having a law that will allow members of Congress to be preventively suspended. No? So tonight's discussion has really been very interesting, and I would like to thank, and I would really like to thank Dean Jord Jharoah Valenton, Dean Soledad Mawis, and Attorney Adonis Gabriel for actually lending their deep insight and conviction to tonight's discussion. It has been free-flowing, and I've enjoyed it very much. I wish Attorney Karen was there also to enjoy tonight's discussion. So, as always, Abogado stands at the crossroads of law, ethics, and governance, reminding us that justice is not only what the law says, but what society expects of those in power. This has been Abogado. Good night.